Every solar panel on your roof has a legal blind spot your neighbor can exploit the moment they decide to build higher, plant taller, or let their trees grow. In most of the United States, installing solar panels creates zero automatic protection against future shade from the property next door. Your right to sunlight is exactly what it was before you spent $30,000 on that system. Nothing. And the legal principle that makes this possible has been settled American law since 1959. The average residential solar installation in the United States now costs between $25,000 and $35,000 before tax credits. Homeowners expect 2 decades of clean energy and lower bills, but they rarely check one critical detail. Under the dominant rule in American property law, the airspace above your neighbor's land belongs to them alone. They can fill it with a second story, a fence line, or a grove of oak trees. And if that structure casts a permanent shadow across your panels, American courts have consistently said the same thing. That is not your neighbor's problem. It is yours. The legal term is air rights. A landowner owns the space above their property, but not the sunlight traveling through it. That distinction is where $30,000 of rooftop hardware meets a legal wall. This principle was locked into place in 1959 by a Florida case that had nothing to do with solar panels and everything to do with shadows. The Fontainebleau Hotel in Miami Beach began constructing a 14-story addition that would cast afternoon shadows over the neighboring Eden Rock Hotel's pool and sunbathing areas. The Eden Rock sued, arguing the shadow would destroy its business. The court reversed the injunction and issued a ruling that still governs American property law today. A landowner does not have a legal right to the free flow of light and air across the adjoining land of his neighbor. The court explicitly rejected the English common law doctrine of ancient lights, which had allowed landowners to claim a prescriptive right to sunlight after long, uninterrupted use. American courts rejected that doctrine because it was seen as inhibiting land development. The implication for rooftop solar is stark. Under the dominant American rule, your neighbor can build a second story, erect a fence, plant a grove of trees, or construct an addition that plunges your solar panels into permanent shade. And you generally have no common law recourse, provided their construction complies with local zoning and building codes. The rejection of the ancient lights doctrine left a legal vacuum. In the United States, there is no inherent common law right to sunlight. The modern statutory framework for solar access emerged only as a reactive policy response, catalyzed by the energy crises of the 1970s. Courts have consistently held that when a structure serves a useful and beneficial purpose, blocking a neighbor's light does not create an actionable nuisance, a legal wrong substantial enough to justify a lawsuit. In the Fontainebleau case, the court noted that even alleged malicious intent by the hotel's president did not convert a lawful improvement into a nuisance that a court could block. The few attempts to expand nuisance law have been limited. In Praw v. Moretti in 1982, the Wisconsin Supreme Court held that blocking sunlight could potentially be a private nuisance under a balancing test, weighing the harm to the solar owner against the social utility of the neighbor's construction. But the court did not create an absolute right to sunlight. It merely opened the door to fact-specific nuisance claims. Justice Callow's dissent warned that the majority was stretching nuisance law beyond its traditional boundaries, and that the decision could create uncertainty for property owners going forward. That was the law on paper. But the part almost nobody knows is what happens when a real neighbor with real trees spends real money to block your real panels. About 38 states, plus Washington, D.C., have some form of solar access legislation. But here is the crucial distinction most homeowners miss. The vast majority of these laws protect you from your homeowners association. They do not protect you from your neighbor. Roughly 30 states have anti-HOA statutes that prevent associations from banning solar panels or imposing restrictions that significantly increase cost. About 25 states have solar easement statutes that create a legal framework for neighbors to voluntarily negotiate and record sunlight protection agreements. But only a handful have neighbor shading statutes that actually restrict what neighboring property owners can build or plant. California's Solar Rights Act limits HOA restrictions. Its Solar Shade Control Act limits tree shading, but only for trees planted after your solar collector was installed. And the act explicitly does not apply to buildings or walls. New Mexico's Solar Rights Act creates a legal right to unobstructed sunlight based on the first beneficial use of the sunlight for solar power. This is one of the few states where solar access functions as a property right rather than a negotiated easement. Wisconsin has a statutory permit system that can grant solar access rights. Colorado allows counties to create zoning ordinances protecting solar access. States without any solar access legislation include Alabama, Alaska, Mississippi, Nebraska, Oklahoma, Pennsylvania, and South Carolina. In those states, solar access depends entirely on private easement agreements under common law, a process with far less certainty. The documented cases reveal how narrow these protections really are. In Sunnyvale, California, in 2008, under the state's Solar Shade Control Act, a resident was criminally prosecuted and convicted for allowing redwood trees to shade a neighbor's solar panels, even though the trees had been planted before the panels were installed. The case sparked national outrage and led to a 2008 amendment. The tree owners spent approximately $37,000 in attorney fees before ultimately being ordered to trim their trees. In Schur versus Leiterman in 1986, two Stanford professors designed a passive solar home with south-facing windows and skylights. When neighboring trees matured and blocked winter sunlight, they sued under the Solar Shade Control Act. The court ruled the act applied only to solar collectors, meaning active systems with panels, not passive solar design. Extending protection to passive solar homes would effectively give protection to all homes with south-facing windows, an unworkably broad reading. Then there is the Culver City palm tree dispute from around 2008. A furniture maker spent $80,000 on solar panels. 2 years later, a neighbor spent $60,000 planting palm trees along the property line, shading the system. The city became involved, trying to negotiate a compromise. No court ordered the trees removed. No judge forced the neighbor to pay damages. The system mediated, and the solar owner absorbed the risk. The scale of exposure is growing fast. Total United States solar capacity reached 287.7 gigawatts as of early 2026, with over 6.1 million systems nationwide. The residential segment installed 4,647 megawatts in 2025 and 1,179 megawatts in the first quarter of 2026 alone. Yet only 7.5% of suitable owner-occupied homes had solar at the end of 2024. The market is projected to grow at roughly 9% annually, reaching approximately 13% adoption by 2030. The industry now supports 280,119 jobs. But no comprehensive national database tracks solar shading disputes. Major industry analysts do not publish dispute statistics. What we know is anecdotal. The few cases that reach courts suggest that as adoption increases and urban density rises, shading conflicts are becoming more frequent. But the vast majority are likely settled privately or remain unreported. Most homeowners who discover their neighbor can legally destroy their solar investment never fight it in court. No one warned them when they signed the contract. The bottom line is cold. In most of the United States, if your neighbor's conforming construction blocks your solar panels, you cannot stop them, unless you have a pre-existing recorded agreement or your state has a specific statute protecting solar access from neighboring construction. Most states do not. Even in states with stronger protections, most statutes do not prevent a neighbor from building a conforming structure that shades your panels. California's Solar Shade Control Act does not apply to buildings or walls. It only applies to trees and shrubs. And even for trees, it exempts those planted before the solar collector was installed. Courts are reluctant to order demolition of conforming structures. Even when solar owners win, remedies are more likely to be damages or negotiated compromises, not injunctions requiring demolition. And under California's Solar Shade Control Act, any city or county can exempt itself entirely. In Zipperer versus County of Santa Clara, the court held that the county could exempt itself retroactively, extinguishing any statutory claim. The only robust protection is a negotiated, recorded solar easement purchased before installation. A solar easement is a voluntary agreement where one property owner agrees not to build or plant in a way that would shade the solar system on the neighboring property. It must be created in writing and recorded with the local property records office. It runs with the land, binding all subsequent owners of both properties. State statutes do not grant an automatic right to sunlight. They create a legal structure for the solar user to purchase that right from their neighbor. American property law has been turning sunshine into a market commodity since 1959. If you are considering solar, proactive legal protection is essential because reactive options are weak or non-existent. Before installation, check your deed and title report for any existing covenants, conditions, restrictions, or easements that might limit solar placement or access. Review HOA rules if applicable. Even in states with strong solar access laws, HOAs may impose reasonable aesthetic restrictions on size, placement, and appearance. Conduct a shading analysis that projects not just current tree shadows, but future growth. Many installers use software to model shading over time. Negotiate a solar easement with neighbors before installing. This is the single most effective protection. A recorded solar easement binds future owners and specifies exactly what construction or vegetation is prohibited. It must be in writing, signed, and recorded with the county. Expect to pay your neighbor for this right. It is a market transaction, not a demand. Send written notice to neighbors before installation. Certified mail notice can strengthen future claims in some jurisdictions. Check local zoning codes for height limits, setbacks, and solar access ordinances. Cities like Berkeley, Boulder, and Santa Monica have specific protections. If a neighbor starts blocking your sun, document everything. Collect inverter generation logs comparing pre- and post-construction output. Take time-stamped photos. Obtain the neighbor's building permit records. If their construction violates setback, height, or zoning rules, you may have an administrative remedy through the building department. Attempt negotiation first. Most disputes resolve faster through mediation than litigation. Consider technical mitigation. Microinverters or power optimizers may recover lost generation from partial shading. Battery storage can also stretch limited solar production. The headline is not hyperbole. Under the prevailing American rule, established in Fontainebleau and reaffirmed across decades of case law, your neighbor generally can build or plant in a way that blocks your solar panels forever. Solar access laws in most states protect you from your HOA, not from your neighbor. The only robust protection is a negotiated, recorded solar easement purchased before installation. If you are investing tens of thousands of dollars in rooftop solar, invest in legal protection before the panels go up. Next week, we are looking at the employment contract clause that lets your employer claim ownership of inventions you create on your own time, using your own equipment in your own home, and why it is enforceable in most states. You will want to see that one.